The officer located 5 adult complainants locked in a bedroom. The officer observed the defendant to be the sole person in the apartment that was not locked.
I'll just say less experienced defense attorneys.
I don't care who, what, when, where, but if I find that you're a public danger, then I will put you in custody.
Those clips you just saw, that is the sound of a man's life unraveling in real time. This case looks like a standard hearing, but dig deeper, and it's a horror movie. We aren't talking about a landlord dispute. We are talking about a stash house, a prison for human beings. At stake today, if the judge believes the police report, this man is a predator holding 5 people hostage in a boarded-up room. If the judge believes the defense, he's just an innocent roommate who had no idea 5 people were locked in the bedroom next door. What unfolds over the next 20 minutes is a masterclass in legal maneuvering. The police found the money, they found the bat, but the defense is about to argue that none of that matters because of one physical detail on the defendant's face. The preview was just the beginning. Let's start from the top.
All right, so Mr. Martinez, you were charged with operation of a stash house. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 24th, 2024, officers were dispatched to an apartment in Harris County, Texas. The officer located 5 adult complainants locked in a bedroom while conducting a welfare check. The officer observed the defendant to be the sole person in the apartment that was not locked in the bedroom. The officer determined the apartment to be under the control of the defendant. All complainants gave similar statements and stated they were held in the locked bedroom without the ability to come and go free. The complainants were all found to be in possession of identifying documents, but their cell phones had been taken away. The complainants stated if they needed to leave the bedroom, they had to knock on the door and be led through the apartment, sometimes with a bag over their head, by one of 2 males in charge. The defendant stated he lived at the location with another male, but that he did not know the other male very well. The defendant denied knowing the 5 people in the apartment. Instead, they were dropped off in the morning that day, but he did not know who dropped them off. The defendant was found with $5,959 on his person, and the officer further observed the door where the complainants were being held could only be locked and unlocked from outside. The room was bare of any furniture. No mattresses were in the room. Only 3 pillows and multiple blankets, and a large sheet of plywood was found covering the window. The officer also found the room had no working light bulbs. The officer observed a desk in the dining area with 4 envelopes with names and $3,600 written on them, containing cash, a total of $11,200.
Notice what nobody else catches here. The judge just slammed on the brakes. Why? Because the math doesn't add up. He's looking at the charge sheet, and it says Class A misdemeanor. That's usually for things like petty theft or minor assault. But the facts he just read, people locked in rooms, smuggling rings, that is serious felony territory. The judge is confused because the police paperwork doesn't match the horror of the crime. He's essentially saying, wait, you found people trapped in a cage and you only charged this guy with a misdemeanor? That hesitation is crucial. He knows something is wrong with the filing, and he refuses to move forward until he understands why. Watch what happens next. He's going to call everyone up and go through the evidence with a fine-tooth comb. And when he does, the details that come out are going to make that initial police report look like a bedtime story. Plywood on the windows, no furniture, and a specific weapon on the desk. Listen closely.
Let's do this. Mr. Martinez, I'm going to have you take a seat in the jury box. I'm going to have to go through this with a fine-tooth comb. Just take a seat for me. We'll come back to you. So come on up. I was going to do a deeper dive on it to see whether there's probable cause. It's the first time I've seen something like this.
Yeah, same here, Judge.
Do you mind do you have somewhere else to go?
I do.
Can you go do that and just come back maybe
Yes,
in
sir.
like an hour? Let me blow through all the arraignments and then
No
we'll sit.
problem. I'm gonna just let my client know and I'll be right back.
Yeah, I mean, I want to open the code. Let's go through it and take time, you know? Yeah, okay, sure.
All right, just trying to say your ear.
Ready? Hey, Morgan, So I'd like to do PC on this case. This is that stash house.
Yes, we're actually talking to Nathan about that right now.
Nathan,
Yes, sir.
this is a very, it's a first for me.
Okay.
A stash house.
Yeah,
Have you seen this before?
I have, but not for a long time.
And I gotta understand,
I'm looking it up right now.
why is it's not higher up? It's not
Most
like
staff
feds?
houses are misdemeanors. It's strange. Most staff houses are. I teach at the police academy. That's why I know.
Okay, we have to do probable cause, and, you know,
I'm looking it up. I'm gonna try and find the pleading itself right now.
okay. Are you ready? Okay, let's do it. What was his name again?
So it's called, I think it's Adolfo on there, but it's Anulfo.
That's right. Mr. Martinez, come on up. Okay, shh. All right, Mr. Martinez, you were charged with operating a stash house. I wanted to make sure that your lawyer was here when we did probable cause. You have the right to remain silent. Anything you say can or will be used against you. Here we go.
Yes, sir. On November 24th, 2024, the officer was dispatched to an apartment in Harris County, Texas. The officer located 5 adult complainants locked in bedroom while conducting welfare check. The officer observed the defendant to be the sole person in the apartment, not locked in the bedroom. The officer determined the apartment to be under the control of the defendant, and all complainants gave similar statements and stated they were held in the locked bedroom without the ability to come and go freely. The complainants were all found to be in possession of identifying documents, but cell phones had been taken away. The complainants stated if they needed to leave the bedroom, they had to knock on the door and be led through the apartment, sometimes with a bag over their head, by one of 2 males in charge. The defendant stated he lives at a location with another male, but does not know the other male very well.
Okay, whoa. So the defendant says that he lives
At that location,
at the location,
but he does not know the second male that also lives at the location.
doesn't know him well, or
Doesn't
doesn't?
know, no.
Okay,
Yes.
all right.
Yes. And the defendant denied knowing the 5 people in the apartment and stated they were dropped off in the morning and that he did not know who dropped them off. The defendant was found with approximately $6,000 on his person, and the officer observed the door where the complainants were to be unable to be locked or unlocked from the inside, only able to be locked from the outside. The room where the complainants were found was free of any furniture, with no mattresses on the floor, and only 3 pillows and multiple blankets. Officers also found a large sheet of plywood covering the window and no working light bulbs. The officer observed a desk in the dining area with 4 envelopes with names in 3,600 written on them containing cash, a total of 11,200. Officers also found a brown wooden baseball bat on the desk with the envelopes.
Pause. Right here. I want you to be the jury. You just heard the list. Windows boarded up with plywood, no mattresses, just pillows on the floor, envelopes full of cash, and a baseball bat on the desk. Now, before I tell you what the defense is about to say, ask yourself, is it possible to live in that apartment and not know what's going on? The defense is about to attempt what we call the blind roommate strategy. They are going to claim he just rents a room there. He wakes up, goes to work, comes home, and somehow misses the 5 people locked in the bedroom and the baseball bat on the dining table. Legally, they have to prove he didn't have control over the hostages. It sounds impossible given the cash in his pocket, but here's the twist. Criminal cases often hinge on identity. The police report says the victims described their captor. The defense attorney has found a massive hole in that description, one detail that doesn't match the man standing in the courtroom. They are about to bet the entire case on this one discrepancy. Watch the judge's reaction when they drop this card.
If I may, Your Honor. So my understanding is that I guess the code says that he has to own the property or rent it, but he was actually renting a room from the guy that lived at that apartment. So he had only paid 1 month of rent to the guy and was going on his second month. He, from my understanding, didn't know who those people were. They had gotten dropped off that morning and he hadn't left for work yet, was my understanding, that day when the officers showed up. And that's all I know from what I gathered. But he had been living there and there hadn't been people there until that morning when they arrived, that the officers then arrived at the home.
Did the officers interview him at all?
Interview the defendant?
Uh-huh.
Yes, Your Honor, and that's whenever he told them that he lived at the location, but did not know the person very well, and that he did not know the 5 people inside. And the officer found them locked in a bedroom, but he denied knowing who they were.
So it says here, a person commits an offense if the person knowingly, 1, uses or permits another to use any real estate, building, room, tent, vehicle, boat, or other property owned by the person or under the person's control to commit an offense or to facilitate the commission of an offense under.
Which is, Judge, those other sections are smuggling or trafficking.
Right. Or rents or leases any property to another, intending that the property be used as subdivision 1.
Which would be him allowing them to use the property for such commission of alleged offense, but it wasn't his. I guess my issue is that it wasn't his property. He was not on the renting or.
And Your Honor, the officers found him to be under the property to be under his control, as they found him to be the only person on the premises at that time, not locked in the bedroom. So yeah, that's why it was the officer's conclusion that he was in control of the property at the time.
What evidence do we, Nathan, what evidence do we have that he knows the persons are being trafficked or being held?
Well, in these cases, typically, Judge, somebody's not going to come out and say, I know everybody's being trafficked in this room. It's going to be a matter of circumstances, the totality of the circumstances, I would say, to make that out. And I believe, Judge, based upon the information that we have, that we're at least there for false cause standard.
And if I may, I did go ahead and read the entire DIM summary, and the complaining witnesses that were found in the home did describe 2 individuals, none of which meet the description of my client. They said one of them was a young male with glasses and an older man with a white beard, is what the 2 individuals told the officers.
And Your Honor, in the full DIMS, the complainant wanted to describe the.
So hold on a second, because are you telling me that the people who are held captive are saying that it's another 2 people who are acting?
Your Honor, there was a description giving older with gray hair, a round face, and a beard, and the officer observed the description given to fit the physical description of the defendant. So there was a description given by the complainant, and the officer observed it to match the defendant.
Well, but at the time he got arrested, he didn't have a beard, so because the mugshot doesn't show a beard, so I would assume. I mean, I would have to see what they said. I just don't think it's.
I think he's there, he's alone, there's $11,000.
Cameras don't usually catch this dynamic, but courtroom veterans know exactly what's happening. The prosecutor is being quiet, too quiet. He let the defense attorney talk. He let them make their blind roommate argument. He let them argue about the beard. Why? Because he knows something they don't. This is a trap. The defense is arguing based on old laws, thinking this is a misdemeanor case where they might get a low bond. But the prosecutor has been looking at his computer screen, realizing the law changed just a few months ago. He is about to deliver a warning that sounds friendly, but is actually a threat. When he says, "Sometimes it comes back worse," he means, stop talking because you are accidentally talking your client into a felony. In the next 60 seconds, the stakes go from a year in jail to a decade in prison. The judge is about to lose his patience, and the defendant is about to find out that the rules of the game just changed. Watch the shift.
I mean,
The other thing too is, Judge, it's my understanding, based upon KDA Farmer's recent, I guess, knowledge of the statute, that it's modified felonies in some cases, which we may be refining this case as a felony. I always try to warn, I'll just say less experienced defense attorneys when you're doing it, and always cause argument. Sometimes it comes back worse when you go to the felonies, which I think may happen in that case. That's early.
be careful what you wish for.
So the statute has changed. I haven't seen what the statute says now, but it.
Are you telling me that it changes? Does it change January 1st?
It looks like there was an amendment in February. It's still in our system, under our pleadings. It's still looking like a class A misdemeanor, but when you read the Texas Penal Code under section 20.07, it is a third-degree felony, and that was amended in February.
Oh, yeah. Yeah, look at that. Under 2026. All right, so, Mr. Martinez, I am going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to engage in this behavior, not to be in possession of any weapons. If you pick up a new case, if I find you with a weapon, if you engage in this type of behavior, I will put you in jail. I will not give you any more PR bonds. I don't know what your status in this country is, but if you're in this country without permission and you go to jail, and immigration finds you while you are in custody, they will put an immigration detainer on you, and you will be stuck in custody until the case is over with and then shipped off to immigration. You are on notice now that I'm going to do everything in my power to protect my county. I don't care who, what, when, where, but if I find that you're a public danger, then I will put you in custody. Do you understand? You have a lawyer. It is your responsibility to stay in touch with counsel, and they will tell you when you have to come back to court. If they tell me that they are unable to reach you because you're not responding to phone calls, text messages, likewise, I will issue a warrant for your arrest. No more PR bonds for you, sir. So we'll just have him sign the bond conditions, and then he's free to go with you.
Thank you, Judge.
Yes, ma'am. And so for what it's worth, it is now a third-degree felony. So I don't know how it's still a Class A at this moment. So
Correct. Let me.
that is charged as an A versus a third degree.
Correct. Let me look into
So
that.
yeah, okay. All right, sir. Do not leave, Roberto. If you can tell him, don't leave until he signs bond conditions, please. And then if you can file those, please.
And just to clarify, no engaging in like behavior and
No weapons, right? Yeah. And no going back to this particular house.
I'm going to say something 90% of you will disagree with. Legally, the defense actually had a point about the description. The victim saw a man with a beard. This guy didn't have one. But in a stash house case, judges don't take chances. The blind roommate defense fell apart because of the money and the baseball bat. But here's the real question, and I want to see your verdict in the comments. Do you think he was the mastermind running the operation, or was he just a low-level guy paid to sit in the house and hold the bat? Was he the wolf, or just the sheepdog? Team guilty, or team scapegoat? Let me know what you would have decided if you were sitting on that bench. And if you want to see more cases where the evidence doesn't match the story, hit that subscribe button. We are just getting started.